Hi, everyone. My name is Jay. I'm a 3L here at Vanderbilt Law School. Thank you for joining us today in today's episode of Professors in Conversation. We have here with us Professor Sudeall. She's the David Daniels Allen Distinguished Chair in Law, and she teaches Constitutional Law 1, which is the structuralism part of con law, as well as a host of other courses that we're going to talk about later today. So welcome, Professor Sudeall. Thank you for joining us today.
Thanks for having me.
So you are the director of the Access to Justice initiative here at Vanderbilt Law. How does that kind of influence your scholarship? And can you tell us a little bit more about that?
Sure. Access to justice is a term that's really used a lot, but it's often used without any explanation of what it means. And a lot of people use it to mean different things. For me personally, I interpret it as one's ability to identify and effectively use legal tools and pathways to resolve your problems. So in essence, can you use the legal system to address or achieve whatever you're trying to achieve? What that means for me in terms of my research and teaching is that I'm often focusing on how everyday people sort of understand and navigate the courts. One thing that's interesting about law school is we spend a lot of time talking about the Supreme Court, right, and about federal courts, but that's such a small piece of our legal system, right? State and local courts hear upwards of 60 million cases a year, whereas the Supreme Court decides 80 merits cases a year. This is a massive part of our legal system that touches so many people's lives, and yet we spend so little time talking about it. And they've really historically been understudied, I think, in the legal academy. Access to justice often, I think, is used to refer to civil justice systems, but I think I'm a little unique in that my work has touched on both civil and criminal, partly because my practice background is in the criminal area, but some of my research has looked at civil courts. So in my research, this is translated into doing empirical work with interdisciplinary scholars, sort of really digging deep into courts and thinking about how they operate, sort of shedding light on how these courts operate in practice and how that's often very different from what we talk about in law school. We talk about courts in this very sort of formalized sense. You imagine the judge in the formal robe and the wooden courtroom and lawyers. That's very different from how most courts actually look and operate. There often are no lawyers. The judge may look different ways. The courtroom may be in different settings. They're often loud, messy, chaotic. If there are rules, they can be very informal, and this can be really overwhelming to people. So in a lot of my classes, I focus on the same issues, or at least the other classes outside of common law and capital punishment. And I know we're going to talk about this later, but I would say as a general matter in these classes, I'm trying to give students a sense of what happens in these courts and what are the challenges that people face, particularly when they don't have a lawyer in these courts.
Cool. You recently wrote a paper titled Justice Citizenship, where you kind of talk about, in addition to how we think about courts in law school and like what they adjudicate and how they function, you kind of argue that there should be a focus on how courts have a relationship with the people that they kind of serve. And in that, you talk about justice citizenship as having 3 prongs. Can you tell us a little bit more about that?
Sure. Like a lot of people these days, I find myself thinking about democracy, and I wrote this paper for a symposium that was focused on access to justice, the rule of law, and democracy. So I spent some time thinking about how do we usually talk about courts in the context of democracy, and we often talk or think about them in juxtaposition with other branches of government, right? How are the courts balancing or checking the executive or the legislature? But courts are themselves democratic institutions, and we don't often think about what that means internally. So the idea behind the paper, or this term, justice citizenship, I use to suggest that people who use the courts are in essence citizens of the courts, and the court should treat them that way. Citizenship often implies a two-way exchange, that we expect that people will pledge loyalty and allegiance to a system in exchange for or in return for certain rights and privileges. Courts often operate in one way in that sense, right? They expect a lot of people who are litigants or who appear before them, but they don't actually, I don't know, it's not clear what they view themselves as owing to those people in that process. So I tried to identify 3 concepts or values that we might think of as defining what courts do owe to the people that they serve as democratic institutions. So the 3 things identified, which are not an exhaustive list, and I think these are not novel concepts, but I was trying to provide this sort of different framing, are equal, informed, and meaningful participation. Right? So do people have whatever they need to actually engage in a meaningful and effective way, not just a sort of nominal way? The idea of self-determination, which I'll return to in a second, and accountability. The idea that even though, right, courts aren't going to be accountable to people in the same way that the executive and the legislature are, but in terms of the process, right, we don't want courts to be co-opted by the political or the majoritarian process necessarily. But right, to the extent that they are the vehicle through which people have to resolve these problems, they should be accessible. And I think there should be a vehicle through which people can actually express or influence if that process is not accessible in some way. So an example of this are things like citizen advisory boards or oversight boards, where people can play some role in providing feedback, for example, to the courts as to whether what they're doing is working well. I'll just mention quickly on the self-determination piece, I have a new paper that's coming out in the spring in the Boston University Law Review called Self-Determination and Self-Represented Litigants. And there I explore this concept of self-determination more. I essentially describe it as the ability of people to sort of vindicate their legal identity through the court process, right? So when you're using the court process, you need legal knowledge, right, to be able to express whatever you want, but people also have personal goals of what they want through the court process, which won't necessarily map onto what a lawyer might think is the best strategic decision. So what I think is interesting if you look at court reform is that, right, sort of on the premise, which is very much true, that most people don't have lawyers and probably won't have lawyers, right? We need to figure out ways to make the court more accessible. And some of that has involved thinking about ways, for example, that the court can do more, right, affirmatively. So things like active judging, where a judge sort of plays a more active role in trying to elicit information from litigants who might not know what they're supposed to say, right, how they're supposed to say it. And I very much support that. I think it's a good development. There are, a lot of questions there, but about how that should work in practice. But one thing that I noticed that was sort of missing from these discussions was, right, how do you then preserve this idea that people can actually use the legal system in the way they want, right? And usually that's what you would rely on a lawyer for, right? If you have a lawyer, you can say, not only do I want to achieve this outcome, but I want to sort of approach this in a more aggressive way or a more conciliatory way, or I don't want this information to be revealed, or retaining a relationship with the opposing party is really important to me. And those types of things, right, it's unclear how somebody in this sort of acting judging scenario would be able to vindicate those same interests. And so what I was interested in was thinking about how can we, in thinking about court reform, sort of ensure that people retain some autonomy or agency in how they want to use the court process for their own personal interests or goals. And if we can't account for that, we should at least acknowledge that it's a trade-off, right? That people who don't have lawyers are not only missing out on sort of legal knowledge and expertise, but also this ability to drive the legal process in the way that they want.
I think like the concepts that you talk about in your paper kind of translate to a lot of the courses you offer in the law school. And your more experiential courses have a lot of appeal to law students in general, as well as like public interest aligned students. What can kind of students do at Vanderbilt Law to kind of get more involved in that, taking your classes and other classes?
Sure. So as you mentioned, I teach Common Law 1. I also teach capital punishment, not every year, but occasionally, which sort of draws on some of my practice background. But I teach a number of different access to justice classes, and I guess I'll mention I'm also going to be teaching one of them in the legal studies minor in the spring, so undergrads can also take this class. So I teach what I think of a more basic or fundamental version of access to justice, which really tries to give students insight into sort of the things that we were talking about earlier, right? How do most courts operate? What's the law that governs whether people have access to lawyers or not? And I think people are surprised to find that people actually have a right to a lawyer in many fewer situations than they would have assumed. And assuming people don't have a lawyer, what does that mean in terms of how they interact with the courts? What obstacles do they face? And what is going on in the world of court reform to try to address some of those things? For example, different uses of technology, uses or expansion to non-lawyers, right? And the ability of other people outside the legal profession to offer assistance. And in that class, I typically ask students to actually craft a discrete reform that could actually help some piece of this process. And I think it's really unique for students. In law school, we spend a lot of time critiquing, but students don't often have the time or the opportunity to think really affirmatively and creatively about how can we actually fix some of these problems. And one thing that's been neat about that class is I actually usually bring in external folks, so people from the courts or local legal service providers. And when the students present to their classmates, but to this audience, often those folks have actually taken some of these ideas and implemented them in practice, which I think is a really, right, and aside from getting an A on your exam, you actually get to feel like you made some tangible impact. In the last couple of years, I've taught a different variation of that course, So with the idea that I wanted law students to have some opportunity to engage with people who are more directly impacted by the legal system outside of this sort of lawyer-client relationship. So that class is called Access to Justice, Legal Education, and Empowerment. And the first iteration of it had law students engaging in dialogue with women who are incarcerated at the local women's prison here in Nashville. Part of what came out of that class was that the inside students, the women who are incarcerated at the facility, really wanted more opportunity to sort of express their own voice outside the prison walls. They really found the discussions they had with the law students engaging and energizing, but they said, wouldn't it be great if we could also take this next step? So always up for a challenge. I've tweaked the class again. And this year, students from the law school are actually working with a group of women at the prison to co-author articles. They're working in 4 different groups, producing 4 articles on different aspects of the criminal legal system, working on a totally equal level, assuming or acknowledging that both groups of students bring their own expertise and knowledge to this task. And the articles will all be published in the Social Justice Reporter in the spring. So, and I have to say, I joke that going to this class every Tuesday really gives me life. It's been so exciting seeing these 2 groups of students so engaged in this sort of joint process of really trying to better understand the law and how it works in practice. And so, surely students who want to do public interest, I think those classes are one way, not just for those students, but honestly any student. I know there are a lot of students in the class who are going to, to big law firms, and I think everyone can get something out of having this kind of interaction and engagement. I think it certainly gives anybody a deeper understanding of the law and legal systems. And I would say, more generally, as to, again, to all students, I think law school offers such a unique opportunity to try things, both in terms of different substantive areas and different types of work. And so I think really taking advantage of that through internships, clinics, researching, being a research assistant to professors. I'm a huge proponent of public interest law. Before I was a law professor, I worked at the Southern Center for Human Rights doing death penalty work and civil litigation around the right to counsel, and it was some of the most fulfilling work I've ever done. So I try to also provide support to students who are interested in pursuing that path, just because I personally think it's really rewarding. But I think there are a lot of opportunities here at the law school that anyone can engage in, whether you're going to do that or do pro bono work at a firm, whatever the case might be.
I think it's so cool. A lot of my friends who are actually going into big law are enrolled in your classes, and they're really excited about it. They're like, oh, I have to go to court to observe what's going on. So I think it's really cool that you're offering this.
So I didn't even mention I'm teaching a court watch practicum with Dean Cruz also, which is a 1-credit course that anybody can take just to get some exposure to these courts, and which are very different from what
a lot of my friends have no legal background. They either came straight through to law school or worked in a non-legal setting before. So it's this is their first time observing how courts work. So they find it really interesting and sometimes fulfilling to see how things work out in favor of people.
And usually surprising. They're usually surprised.
Right. And then always oh, today is housing court or family court. And they're like, oh my God. So it's really interesting to hear kind of a student's perspective of how these courses are kind of work for them, even though it may not be something that they're pursuing as a career. I think it's really cool.
Well, that's great.
Thank you so much for taking the time to speak with us today. And thank you to the audience for joining us today in today's episode of Professors in Conversation. I hope you join us for the next one. Thank you.